At Research Expert Solutions, we are passionate about bridging the gap between Zambia's legal systems and the public. Our mission is to bring you closer to the inner workings of the High Court of Zambia by documenting real cases that shape our nation's legal landscape. Through these documentary videos, we aim to enlighten, educate, and inspire curiosity about how justice is served in Zambia, one case at a time. Today, we embark on this journey with an intriguing case heard in the High Court for Zambia, Commercial Division, located in the bustling heart of Lusaka. This case, which has captured the attention of legal professionals and the public alike, delves into the intersection of corporate operations and consumer protection. The case is officially titled African Banking Corporation Zambia Limited Trading as Atlas Mara v. the Competition and Consumer Protection Commission, re Allan Moosho. This case provides a fascinating look into how Zambia's legal system navigates disputes between powerful corporate entities and regulatory bodies established to protect the interests of consumers. Presiding over this case is Honorable Mr. Justice L. Monabo, whose meticulous approach to justice promises a fair and insightful judgment. The session took place on the 25th of November, 2024, in the Commercial Division of the High Court. Representing the appellant, African Banking Corporation Zambia Limited, commonly known as Atlas Mara, was a formidable legal team comprising Mrs. M. B. Mutuna from the law firm Messrs. Mweshi Banda Associates, alongside in-house counsel Mrs. T. Banda. On the other side of the courtroom, advocating for the respondent, the Competition and Consumer Protection Commission, was their in-house counsel, Ms. T. Chola. This case raises significant questions about the balance of power between corporate giants and regulatory authorities in Zambia. As we unpack the details of this legal battle, we will explore the claims, defenses, and the implications of the High Court's decision on Zambia's commercial and consumer protection landscape. Stay with us as we unravel the story behind Atlas Mara versus the Competition and Consumer Protection Commission and discover the precedents, arguments, and legal principles that guided the court's decision. So, how did this case make its way to the Commercial Division of the High Court in Lusaka? And what did the court have to say about the issues at hand? Let's dive into the details and bring you the full story. The case is an appeal against the decision of the Competition and Consumer Protection Tribunal, which upheld the ruling that found Atlas Mara in breach of Section 49(5) of the Competition and Consumer Protection Act. As a result, the bank was fined and directed to reconstruct the complainant's loan account to provide clarity on all transactions, debits, and credits. This dispute traces back to a series of loans obtained by Mr. Allan Moosho from Bank ABC, now Atlas Mara, between 2012 and 2021. Mr. Moosho initially secured a loan of 15,000 kwacha in 2012, followed by a second loan of 30,000 kwacha in 2014. This second loan, scheduled to run for 60 months, became the crux of the legal battle. According to Mr. Moosho, he settled the loan in 2019, yet disputes over outstanding balances arose. In 2021, after obtaining a third loan of 75,000 kwacha, Mr. Moosho discovered his account had been blocked, with 23,000 kwacha redirected to cover alleged arrears on his second loan. Atlas Mara attributed this to adjustments in interest rates between 2016 and 2017. However, Mr. Moosho contended he was never notified of such changes and provided pay slips as evidence of full payment. The tension escalated when, in 2022, Mr. Moosho noticed deductions of 500 kwacha from his salary towards what the bank claimed was an outstanding balance. He sought legal intervention to stop these deductions and recover the amounts deducted after his purported loan settlement. Atlas Mara countered these claims by outlining discrepancies in Mr. Moosho's payment history. The bank argued that the second loan was rescheduled due to an adjustment in the monetary policy rate by the Bank of Zambia in 2016. This adjustment extended the loan tenure from 60 to 68 months, an agreement the bank claimed was signed by Mr. Moosho. Atlas Mara also stated that Mr. Moosho missed 4 installments during the loan period, resulting in accrued interest that increased the loan balance. Furthermore, the bank contended that part of the 75,000 kwacha loan obtained in 2021 was meant to refinance the remaining balance on the second loan, yet Mr. Moosho withdrew most of the funds, leaving only 5,000 kwacha to settle the debt. At the heart of this case lies a disagreement over communication, transparency, and loan management. Mr. Moosho claims he was not informed of interest rate changes, while Atlas Mara insists it acted within its rights. The tribunal's ruling sided with the borrower, emphasizing the bank's responsibility to exercise reasonable care and skill. This case serves as a compelling example of the challenges borrowers and lenders face in Zambia's financial sector. It underscores the importance of transparency, effective communication, and adherence to regulatory guidelines to maintain trust and accountability. Stay tuned as we explore the outcome of this case and its implications for Zambia's banking and legal landscape.
The matter before the board centered on whether the appellant, African Banking Corporation Zambia Limited, commonly known as Atlas Mara, violated Section 49(5) of the Act. At the heart of the issue was a complaint from a consumer who had obtained loan facilities from the bank for personal use. This case raised questions about whether the bank had provided its services with reasonable care and skill, and whether it adhered to agreed terms and timelines. The board began its assessment by examining two critical points. First, whether the bank, as an enterprise, supplied services to the consumer, and second, whether those services were supplied with the necessary care, skill, and within a reasonable time. To understand the situation, let's start in January 2014, when the complainant took out a loan of 28,000 kwacha to be repaid over 60 months. Along the way, missed payments in 2015 and 2016 extended the repayment period. During this time, the Bank of Zambia made adjustments to the monetary policy rate, MPR, with significant increases in 2015 followed by reductions in later years. However, the bank failed to adjust the interest rates on the consumer's loan in line with these changes, creating a ripple effect of financial strain. By April 2020, when the complainant made what should have been their final payment, a series of issues had already come to light. The missed installments and unadjusted interest rates caused the loan balance to rise unexpectedly, reaching 21,562 kwacha by the end of 2020. Despite these complications, the bank failed to notify the complainant in a timely manner, leaving them unaware of the growing debt. The board's findings were clear. Atlas Mara had not only neglected to adjust the loan in response to MPR changes but had also failed to communicate these omissions promptly. This, the board concluded, amounted to a lack of reasonable care and skill, key requirements for any enterprise supplying financial services. The decision was equally decisive. The board found the bank in violation of Section 49(5) of the Act for engaging in unfair trading practices. To address this, the bank was fined 0.5% of its annual turnover. Further, it was directed to restructure the complainant's loan, ensuring that only the outstanding balance as of the original loan term's end was recovered, excluding the accumulated interest from subsequent delays. The bank was also required to submit its latest financial records for fine calculations and to comply with directives aimed at preventing similar issues in the future. This case is a reminder of the role regulatory bodies play in protecting Zambian consumers from unfair practices. The board also called for a broader market survey to assess whether banks in Zambia adjust loan tenures equitably when the MPR changes. Such efforts are vital to ensuring a balanced and transparent financial system. For Atlas Mara, the decision came with a clear directive: accountability and compliance are non-negotiable. The bank was given the opportunity to appeal within 30 days, but the implications of this case go beyond one institution. It serves as a wake-up call for all financial entities in Zambia to uphold fairness and transparency in their operations. In the end, this story is not just about one complainant and one bank. It's about reinforcing trust in Zambia's financial system, ensuring that every consumer is treated with fairness, respect, and care.
The matter before the tribunal was one of significant contention, as it involved an appeal filed by the appellant against a decision made by the board. On September 19, 2022, the appellant presented 7 grounds of appeal, seeking to overturn findings that included breaches of banking laws, unfair trading practices, and issues related to loan management. This case is an important reminder of how regulatory frameworks and financial institutions intersect in Zambia. The first ground of appeal revolved around the assertion that the respondent, or the board, erred in holding the appellant liable for breaching Section 49(5) of the Competition and Consumer Protection Act. The appellant argued that this decision was contrary to banking customs and regulations that prescribe the standard of care and skill for banks. However, the tribunal considered the evidence and determined that the appellant failed to exercise reasonable skill and care in managing the complainant's loan. Specifically, the tribunal noted that the appellant did not inform the complainant about the extended loan tenor and associated deductions. This lack of communication led to unnecessary confusion and financial strain for the complainant. As a result, the tribunal upheld the finding of a breach of Section 49(5). Moving to the second ground, the appellant contended that the respondent erred in finding them guilty of unfair trading practices, citing an absence of supporting evidence. However, the tribunal referred to a precedent, the case of Development Bank of Zambia versus Stalwart Investment Limited and others, to support its decision. It was evident that the appellant's failure to adjust loan pricing in line with Bank of Zambia (BOZ) guidelines disadvantaged the complainant. This conduct was deemed inconsistent with good banking practices and constituted an unfair business practice. Consequently, the tribunal upheld the board's decision on this ground as well. The third ground of appeal addressed the appellant's failure to communicate changes in interest rates and the resulting impact on the loan balance. The tribunal found this lack of communication to be negligent, further demonstrating a failure to provide the requisite level of care and skill. The tribunal emphasized that it was the appellant's responsibility to inform the complainant of any changes affecting their financial obligations. As such, this ground of appeal was dismissed. On the fourth ground, the appellant argued that the respondent failed to acknowledge the complainant's accountability for breaching the loan agreement. However, the tribunal noted that the appellant did not provide a copy of the loan agreement for review. Without this key document, the tribunal was unable to assess the specific terms and conditions governing the complainant's obligations. Even so, the tribunal acknowledged that the complainant had missed 4 loan payments during the initial 60-month period, but this did not absolve the appellant of its own responsibilities. The fifth ground of appeal focused on the appellant's alleged failure to implement adjustments following changes in the monetary policy rate, MPR, in 2016. Referring to relevant BOZ circulars, the tribunal found that the appellant had only effected one upward interest rate adjustment. This finding aligned with the respondent's position, and the tribunal concluded that there was no merit in the appellant's argument. Ground 6 brought forth a critical question regarding the respondent's authority to direct the appellant to restructure the complainant's loan. The appellant argued that they had notified the complainant of the MPR increase and had prior permission to extend the loan tenor. However, the tribunal concluded that the respondent acted within its mandate under the Act and that the direction to restructure the loan was justified. This ground also failed. Finally, on the seventh ground, the appellant challenged the fines imposed, arguing that they were inconsistent with the respondent's published guidelines. The tribunal examined the matter and found that the fines were appropriately calculated, aligning with the guidelines. Thus, this ground of appeal was dismissed as well. Therefore, the tribunal considered the evidence and submissions from both parties and identified 3 key questions for determination. First, whether the appellant exercised reasonable care and skill in managing the loan. Second, whether the board's directive to restructure the loan was valid. Third, whether the fines imposed were consistent with the guidelines. After thorough deliberation, the tribunal found in favor of the respondent on all counts, dismissing the appeal in its entirety. This case serves as a vital example of the importance of adherence to regulatory standards in Zambia's financial sector, ensuring accountability and fairness for all stakeholders.
The matter before the tribunal was one of significant contention, as it involved an appeal filed by the appellant against a decision made by the board. On September 19, 2022, the appellant presented 7 grounds of appeal, seeking to overturn findings that included breaches of banking laws, unfair trading practices, and issues related to loan management. This case is an important reminder of how regulatory frameworks and financial institutions intersect in Zambia. The first ground of appeal revolved around the assertion that the respondent, or the board, erred in holding the appellant liable for breaching Section 49(5) of the Competition and Consumer Protection Act. The appellant argued that this decision was contrary to banking customs and regulations that prescribe the standard of care and skill for banks. However, the tribunal considered the evidence and determined that the appellant failed to exercise reasonable skill and care in managing the complainant's loan. Specifically, the tribunal noted that the appellant did not inform the complainant about the extended loan tenor and associated deductions. This lack of communication led to unnecessary confusion and financial strain for the complainant. As a result, the tribunal upheld the finding of a breach of Section 49(5). Moving to the second ground, the appellant contended that the respondent erred in finding them guilty of unfair trading practices, citing an absence of supporting evidence. However, the tribunal referred to a precedent, the case of Development Bank of Zambia versus Stalwart Investment Limited and others, to support its decision. It was evident that the appellant's failure to adjust loan pricing in line with Bank of Zambia (BOZ) guidelines disadvantaged the complainant. This conduct was deemed inconsistent with good banking practices and constituted an unfair business practice. Consequently, the tribunal upheld the board's decision on this ground as well. The third ground of appeal addressed the appellant's failure to communicate changes in interest rates and the resulting impact on the loan balance. The tribunal found this lack of communication to be negligent, further demonstrating a failure to provide the requisite level of care and skill. The tribunal emphasized that it was the appellant's responsibility to inform the complainant of any changes affecting their financial obligations. As such, this ground of appeal was dismissed. On the fourth ground, the appellant argued that the respondent failed to acknowledge the complainant's accountability for breaching the loan agreement. However, the tribunal noted that the appellant did not provide a copy of the loan agreement for review. Without this key document, the tribunal was unable to assess the specific terms and conditions governing the complainant's obligations. Even so, the tribunal acknowledged that the complainant had missed 4 loan payments during the initial 60-month period, but this did not absolve the appellant of its own responsibilities. The financial institution filed an appeal with the High Court, presenting 9 grounds. Let's dive into some key aspects of this case. Ground 1. The appellant argued that the tribunal made an error by claiming they breached their duty under the Banking and Financial Services Act of 2017. The tribunal said the appellant failed to inform the complainant about changes in loan interest rates due to an increase in the monetary policy rate, or MPR. But the appellant countered, asking, which section of the law imposes such a duty? Ground 2. Here's where it gets even more interesting. The tribunal relied on a Kenyan court case to make its judgment, saying general banking practice requires lenders to inform borrowers about pricing adjustments. However, the appellant pointed out that Kenyan laws don't apply in Zambia. They felt it was wrong to use a foreign case as a basis for judgment. Ground 3. The appellant claimed the tribunal misunderstood the evidence and misapplied another Zambian case, Development Bank of Zambia versus Stalwart Investments Limited. They argued that this misinterpretation led to an unfair judgment against them, accusing them of engaging in unethical business practices. Now, picture this. The loan agreement between the financial institution and Mr. Moosho allowed for adjustments in interest rates. Yet, the tribunal ruled that the appellant should have sought prior approval for these adjustments. The appellant insisted this was not required by law and that the complainant had already consented to these terms when signing the agreement. This forms the crux of Ground 4. Grounds 5 to 9 delve deeper into procedural missteps, including reliance on unpublished guidelines, misinterpretation of evidence, and even penalties imposed by the tribunal under sections of the Competition and Consumer Protection Act. The appellant's lawyer, Mrs. Matuna, skillfully presented arguments to support the appeal. She emphasized that Zambian laws, not foreign precedents, should govern the case. She also highlighted the appellant's reliance on the Bank of Zambia's monetary policy rate when adjusting loan interest rates, a practice in line with industry norms. One of the most compelling points came when the lawyer reminded the court that the loan in question was part of a scheme loan. This meant changes to the loan terms were communicated to the borrower through their employer. So, why then was the tribunal insisting on separate notifications? Finally, the lawyer argued that the tribunal's reliance on foreign cases, such as the Margaret and Jerry Muriuri versus Bank of Baroda case from Kenya, was flawed. She pointed out that these cases dealt with laws not applicable in Zambia and that they didn't reflect the provisions of our Banking and Financial Services Act.
Imagine this. A consumer in Zambia takes out a loan from a bank, trusting that all terms will be communicated clearly and handled with care. But later, they discover an outstanding balance on their loan they weren't informed about. How could this happen? This scenario forms the heart of a case brought before Zambia's consumer protection authorities, and it's one that raises vital questions about fairness, transparency, and the responsibilities of financial institutions. The respondent in this case argued that their mandate, as laid out in Zambia's Competition and Consumer Protection Act, is to protect consumers against unfair trade practices. Their role includes reviewing business practices, investigating unfair trading activities, and imposing sanctions where necessary. Under this act, the respondent asserted that its authority applies to all economic activities within Zambia, regardless of whether the entity is regulated by other laws. Simply put, if a business is operating in Zambia, it must comply with consumer protection standards. To illustrate their point, the respondent referenced the definition of economic activity from a European case, which describes it as offering goods and services on a given market. In this context, providing a loan clearly qualifies as an economic activity. The respondent highlighted evidence showing that the appellant, in this case, provided a loan service to the complainant. However, during investigations, it was found that the bank failed to manage the loan with reasonable care and skill, a breach of Section 49(5) of the Act. This section specifically requires enterprises to provide services with due diligence and competence. The respondent emphasized that even if a sector is governed by another law, such as banking regulations, the Competition and Consumer Protection Act holds overarching authority. They cited a previous case where this principle was affirmed, stating that the Act's provisions take precedence over sector-specific regulations, reinforcing its purpose of safeguarding consumers against unfair practices. An example of the bank's shortcomings was its failure to notify the complainant about changes to their loan agreement. In 2019, the Bank of Zambia issued a directive requiring banks to inform customers about changes to lending rates and provide options for managing such changes. Yet, the complainant only learned about an outstanding balance when attempting to apply for a new loan in 2021. This lack of communication, the respondent argued, violated the directive and showed a lack of reasonable care in handling the loan. The tribunal's judgment supported this position. It held that the appellant had a statutory duty to manage the loan responsibly. The tribunal's decision was rooted in Zambian law, specifically the Competition and Consumer Protection Act, rather than other banking regulations. The respondent maintained that this approach was justified because the Act is designed to address precisely these kinds of consumer issues. To strengthen their argument, the respondent referred to cases from other jurisdictions. For instance, in a Kenyan case, a bank was found to have acted unfairly by increasing interest rates without proper notification. Similarly, the appellant in Zambia's case had adjusted the loan terms without adequately informing the complainant. The tribunal found these parallels persuasive, as they highlighted universal principles of fairness and accountability in financial dealings. Finally, the respondent pointed to testimony from the appellant's own witness, who acknowledged the role of the Bank of Zambia's monetary policy rate in determining interest rates. This testimony reinforced the idea that the bank should have communicated any changes affecting the loan. By failing to do so, the appellant breached its obligations under both the law and the directives issued by the central bank. In conclusion, the respondent argued that their actions were consistent with their mandate to protect consumers and enforce Zambia's consumer protection laws. They contended that the tribunal's decision to uphold the board's findings was sound and urged that the appeal be dismissed. At its core, this case serves as a reminder of the critical role consumer protection plays in ensuring fairness and accountability in Zambia's economic landscape. For Zambians, it underscores the importance of transparency and care in all financial transactions, values that every enterprise must uphold to maintain trust and confidence in the market.
Imagine taking out a loan to solve a pressing need, trusting your bank to handle the terms fairly and transparently. But what if that trust is shaken, and you find yourself caught in a financial maze with unexpected deductions and mounting balances? This is the story of Mr. Moosho, a Zambian customer who found himself in a prolonged battle with his bank, Bank ABC, over a series of loans and adjustments. The origins of this case date back to 2012 when Mr. Moosho obtained a 15,000 kwacha loan from Bank ABC. By 2014, he refinanced it with an additional 30,000 kwacha. Over the years, he diligently made repayments, believing the loans were fully settled by 2019. However, his financial journey took an unexpected turn in 2021 when he applied for another loan of 75,000 kwacha. The funds were deposited into his account, but soon after, he discovered that his account had been blocked. Upon inquiry, Bank ABC informed him of an outstanding balance of 23,000 kwacha from his earlier loans, attributed to adjustments in interest rates between 2016 and 2017. According to the bank, these adjustments were communicated to clients, but Mr. Moosho insisted he never received any such notification. Despite his protests and proof of repayment, the bank deducted 10,000 kwacha from his account, reducing the balance to 13,000 kwacha. The dispute deepened when, in April 2022, Mr. Moosho discovered that Bank ABC had resumed deductions of 500 kwacha monthly for a projected 40 months. Frustrated, he sought legal redress, alleging that the bank's actions were unjust and lacked proper communication. On the other side, Bank ABC argued that the loans had been refinanced and rescheduled due to adjustments in the Bank of Zambia's monetary policy rate, MPR. They claimed that these changes, alongside missed installments, resulted in arrears that accumulated interest. According to the bank, Mr. Moosho had signed agreements covering these adjustments, making the deductions lawful. The case was brought before a tribunal, which analyzed the situation under two critical questions. First, had Bank ABC provided the loan service to Mr. Moosho with reasonable care and skill? And second, had they communicated effectively and in a timely manner about the adjustments and missed payments? The tribunal found that Bank ABC did not inform Mr. Moosho of his outstanding balance or the effects of the missed installments and interest adjustments within the agreed loan period. The silence from the bank allowed the balance to accrue additional interest, leaving Mr. Moosho in the dark until deductions resumed in 2021. This lack of transparency was deemed a breach of reasonable care and skill, a principle that requires service providers to act with the competence expected in their field. The ruling highlights an essential lesson for both Zambian consumers and financial institutions. Transparency and effective communication are not just ethical obligations but legal responsibilities. For Mr. Moosho, this case became a battle for fairness, one that resonates with many Zambians who entrust their financial well-being to institutions. This story underscores the importance of understanding the terms of loans, questioning unclear deductions, and holding service providers accountable. It also serves as a wake-up call to financial institutions in Zambia to prioritize clear communication and customer care to build trust and ensure compliance with the law. Stay tuned for more stories like this that shed light on real-life cases impacting Zambians and what we can learn from them.
In Zambia, the relationship between banks and their customers is governed by strict regulations designed to ensure fairness, transparency, and accountability. But what happens when these standards are not met? Let's explore a fascinating case where these principles were put to the test. On page 219 of the Record of Appeal, AW, a witness for the appellant, was asked a crucial question by the Respondents' Counsel. Are you aware of the Bank of Zambia's directive regarding how banks should communicate changes in rates to customers? AW responded plainly, I am aware. This simple acknowledgement unraveled a series of revelations about how the appellant handled their obligations under the directive. In another part of the record, AW admitted to uncertainty about whether specific customers were notified about rate changes. While he stated that SMS notifications were sent in 2020 regarding outstanding balances, there was little evidence to show comprehensive communication about adjustments to borrowing rates. The Bank of Zambia's directive, issued on April 30, 2019, was clear. It required banks to explain the implications of rate increases to customers and provide options, such as extending the loan tenure or increasing monthly repayments. Although this directive came into force after the complainant's loan was issued, it applied during the loan's tenure. The tribunal examined whether the appellant exercised reasonable care and skill in communicating these changes. They found gaps in evidence. Letters were allegedly sent through line ministries and notices were placed in newspapers, but none of this was substantiated. Even SMS notifications lacked proof. The tribunal noted that under Section 49(5) of Zambia's Competition and Consumer Protection Act, banks must supply services with reasonable care and skill. Failure to communicate effectively constituted a breach of this statutory duty. Interestingly, the tribunal referenced the Kenyan case, Margaret and Jerry Mweriri v. Bank of Baroda, Kenya, Limited. In that case, the Kenyan court held that failing to notify borrowers of interest rate adjustments materially altered the loan contract. While the appellant argued that this was irrelevant to Zambia, the tribunal clarified that it used the case only for its persuasive value. The real issue, however, was supported by the appellant's own evidence and directives from the Bank of Zambia. This case serves as a critical reminder for banks in Zambia. Transparency isn't optional, it's a legal obligation. The tribunal's decision emphasized that failing to communicate rate adjustments not only affects trust but also violates statutory duties. As Zambians, we must stay informed about our rights as customers. Whether it's a loan, a savings account, or any other financial service, clarity and communication are essential. After all, understanding these principles empowers us to make better financial decisions. Stay tuned for more insights into cases that shaped Zambia's financial and legal landscape. Knowledge is power.
Ground 5. The appellant challenged the board's decision, claiming it erred in failing to recognize the complainant's breach of their loan agreement obligations. The tribunal, in its evaluation, referred to the board's findings, which noted that missed installments and monetary policy adjustments led to the loan accruing interest, with a balance reaching 17,929.92 kwacha by April 18, 2020. Interestingly, the appellant failed to produce the loan agreement itself, a critical piece of evidence that could have clarified the complainant's obligations. This omission left the tribunal unable to further assess the appellant's claims. While the board acknowledged the complainant's missed payments, the issue at hand was whether the appellant had acted with reasonable care and skill in managing the loan. Ultimately, the tribunal found no merit in this ground of appeal, emphasizing that the complainant's accountability did not absolve the appellant from its duty to ensure fair treatment. Ground 6. The next point of contention was the tribunal's use of Bank of Zambia circulars from 2012. The appellant argued that these circulars were irrelevant, as neither party had referenced them. However, the tribunal explained that the circulars were cited to provide context on monetary policy rate adjustments and how commercial banks applied them. The tribunal emphasized the importance of equipping itself with relevant knowledge, even invoking judicial notice, a principle allowing courts to recognize widely known facts without needing further proof. As a result, this ground of appeal was also dismissed as lacking merit. Ground 7. Ground 7 raised multiple issues, including interest rate adjustments, monetary policy rate, MPR, changes, loan management fees, and penal interest. The appellant claimed that the tribunal had overstepped by addressing matters not raised during the proceedings. However, the tribunal clarified that interest rate adjustments were central to the dispute. It reviewed the evidence and noted discrepancies in the appellant's claims. Specifically, while the appellant argued that the loan tenor was extended due to MPR adjustments in 2016, the tribunal found no evidence to support this. In fact, it discovered from Bank of Zambia's 2016 annual report that the MPR had remained steady at 15.5%, contradicting the appellant's assertions. This led to a reprimand for providing false information. However, on the issues of loan management fees and penal interest, the tribunal admitted a misstep. These matters had not been raised before the board or during proceedings, and the appellant was not given an opportunity to address them. As such, the tribunal's decision on these specific points was deemed a misdirection, leading to a partial success for the appellant on this ground. Yet, this partial victory did not absolve the appellant of its core responsibilities in the complaint.
Section 49 of the Act provides clear guidance on the penalty for breaching the regulations concerning the provision of services to consumers. The Act dictates that if a person or enterprise fails to deliver services with reasonable care, skill, or within a reasonable time, a penalty is imposed. This penalty is calculated as a fine not exceeding 10% of the person's or enterprise's annual turnover, and the individual or enterprise is required to refund the consumer or redo the service if possible. This is the specific penalty for breaching Section 49(5) of the Act. However, when the respondent cited Sections 5(b) and (f) of the Act to impose additional sanctions, the appellant challenged this move, arguing that the sanctions were not specifically mentioned in the Act. The judgment clarified that while Section 5 relates to administrative functions, it cannot extend to adjudicative jurisdiction or sanctions outside those expressly provided under Section 49 of the Act. The tribunal's approach to imposing additional penalties was, therefore, seen as overreaching, as it went beyond what was legally stipulated. Despite this, the tribunal did have the authority to order the restructuring of the complainant's loan based on Section 49(7) of the Act. This part of the Act allows for corrective actions like restructuring, even if the reference to Section 5(d) was incorrect. The judgment cited the Zinka v. Attorney General case, which underscored that the use of a wrong reference to a legal power does not necessarily invalidate the action, as long as it can be justified under another lawful power. Ground 9 of the case brought attention to the use of an unpublished fee unit, which contained an error. The tribunal acknowledged this error and argued that the fines published in the guidelines at the time of the offense should apply, rather than the unpublished fees. This concern about fairness and transparency is aligned with the rule of law principle, which emphasizes that laws should be clear, predictable, and applied consistently. The decision to uphold the penalties based on the incorrect fee unit was, therefore, revisited and adjusted in light of this error, ensuring that the appellant was not penalized under a law that was not properly communicated to the public. In the end, while some grounds of the appeal were dismissed, the penalty imposed by the tribunal was reduced to align with the guidelines as they stood at the time, ensuring that the appellant was treated fairly within the confines of the law. This case highlights the importance of transparency, consistency, and adherence to clear legal procedures, ensuring that both individuals and enterprises in Zambia are held accountable in a manner that is both just and predictable. We've come to the end of our first episode on this case, officially titled African Banking Corporation Zambia Limited Trading as Atlas Mara v. the Competition and Consumer Protection Commission, re Allan Moosho. We hope you found the insights into this legal matter as fascinating as we did. Don't forget to subscribe to our YouTube channel to stay updated with the latest documentaries on high court cases here in Zambia. You won't want to miss any of our future episodes that break down key legal decisions and bring you closer to the stories that shape our country's legal landscape. Thanks for watching, and we'll see you in the next episode.